Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. On April 24th, 2025, the court rendered an order on defendant's motion in limine regarding vague and undisclosed expert testimony. This has to do with numerous state disclosed experts. So what I'm going to do is to provide what the general ruling is, and then in future episodes of this podcast, address each of the experts. Let's begin by looking at what the court's ruling was. The defendant moved to limit or exclude several different experts disclosed by the state on the grounds that their disclosures were deficient in some regard. So note that the objection is with the disclosures themselves, the rules of evidence, and also Judge Hippler's October 9th, 2024 pretrial and trial order directed both sides to make certain disclosures about expert witnesses, and that the disclosures were to contain certain information. Number one, the names of the expert witnesses proposed. Number two, their curriculum vitae, which is another word for a resume, where their skills, their knowledge, their experience, the criteria for being able to, for instance, determine if they are truly experts in the fields proposed would be indicated, and then their proposed what they were going to be testifying to trial about, what their opinion would be. With that said, the state responds that it has complied with all discovery obligations. In other words, it has disclosed what it was required to, is what the state is saying here, and that their disclosures are sufficient. The state adds that several of defendants' challenges are fodder for cross-examination, not exclusion. And what this basically means, fodder, is that the defendant is improperly raising objections here in a motion in limine to exclude or limit them if he has any concerns with any individual expert, that this would be something that could be taken up at trial upon cross-examination, when the defense will have the opportunity to cross-examine each and every one of the state's experts, and vice versa. The state will have the opportunity at trial to also cross-examine the defense's proposed experts. So what the court found here is that there is no basis to exclude or limit the disclosed expert testimony at this time, but if defendant believes an expert is testifying at trial outside of the scope of his or her disclosure, he may object at that time, and the court will consider it. Now, with this said, the court then goes into the standard of what must be shown here. A trial court's decision regarding discovery violations must be supported by substantial and competent evidence in the record, citing to State versus Koch. This is a 2014 Idaho Supreme Court case. And then saying choice of sanctions, including something like striking or limiting an expert's opinion testimony for failure to comply with discovery obligations, the court notes, or whether to impose a sanction at all is discretionary, meaning the court has latitude in determining what, if anything, should be done, citing to State versus Cochran, which is an Idaho 1997 appellate court decision. And then he goes into further details regarding the law before going into the individualized experts proposed by the states. The court did raise an issue sua sponte on his own regarding one of these experts' opinions, finding that even though the defense didn't raise it, he had a question about the potential relevancy of what's been stated in one of the expert disclosures. We're going to get to that in the next episode of the Indie Zone podcast, as well as in future podcasts dealing with each and every one of the findings as it relates to the individualized experts. This is Kathy. Thank you for joining us here today.